Hi, I'm Ben Schwartz. I am an attorney and I handle, for the most part, personal injury cases. Today we're doing a special video. This is a video for physicians, specifically for physicians who are called upon to give videotape depositions in personal injury litigation matters. I've been asked by a number of different doctors over the years, hey Ben, can you give me some training so that when I appear on video in a videotape deposition, I'll know what to do? And I've gone over this numerous times. I've taught lessons on this privately with friends who are physicians who have to give depositions. And I figured if I did a video on this, it might be helpful not only to my friends who have to give depositions, but also to other physicians out there who might be looking for some resource on the internet to give them some guidance on how to go about doing a videotape deposition. So these are my 11 best tips for physicians on giving effective video depositions in personal injury cases. Number one, look into the camera lens, or don't look into the camera lens, but pick one or the other and stick with it. Oftentimes, when a doctor does a videotape deposition in a personal injury case, they never look at the camera lens. Oftentimes, you've got a physician who is sitting at the head of a table. To their left is the plaintiff's attorney, to their right is the defense attorney, and they turn their body and they talk to the plaintiff attorney. The plaintiff attorney asks questions, they answer the questions, and then they get cross-examined and they turn their body and they answer the defense attorney's questions. That's fine. There's nothing wrong with that if that's what you want to do. But I think the thing to realize is that if you're giving a videotape deposition, the viewer of that deposition video is not going to be these attorneys. The viewer of the deposition video is the jury in the trial. And what the jury is seeing is they're seeing you talk to some invisible person who's off screen over here. Then they're watching you talk to some invisible person who's off screen over there. And you're not engaging with your audience. If you want to give an effective deposition, if you want to be convincing, if you want people to follow along with you, then the way to do it is you look directly into the camera lens and you maintain your focus there, just like I'm doing right now. If you're watching this video, it probably doesn't strike you as odd that I'm looking directly into the camera lens, but from this side of the camera lens, it really is odd because I'm talking to a little dot on the back of an iPad. It sort of makes me feel uncomfortable, but I force myself to do it because I know that when you watch this video, you'll feel like I'm talking directly to you, even though you weren't here when I said these words. So my point to you is, if you want to do it, if you want to record a video deposition where you're talking to the plaintiff attorney, you're talking to the defense attorney, and you never look at the camera lens, that's fine. It won't come off as being strange. It'll come off as you giving a videotape deposition. If you want to give the deposition and you'll have the attorney over here out of the corner of your eye asking you questions, yet you will answer to the camera lens, or you'll have the attorney over here out of the corner of your eye asking you questions, yet you'll answer directly to the camera lens, it will feel strange when you're giving the deposition. It will seem strange to the attorneys. It'll feel weird to you, but when you go back and watch the video, when the jury watches the video, they'll think that you're talking directly to them, and it'll be much more convincing to them than if you looked either way. Number two, use demonstrative aids. So if you're a doctor and you're giving a videotape deposition and your patient has a disc herniation and you want to talk about what the disc is, where it is, and how it's herniated, get something so you can show the viewers on the videotape, this is what I'm talking about. Because if you just talk about it in the abstract, it's rather hard for the jurors at trial to understand what you're talking about. If you gave someone, if you did surgery to do a hip implant, if you can get the hip implant and have it available so you can show the jury what you implanted in that plaintiff's body, that would be great. If you give a facet joint injection under fluoroscopic guidance and you happen to have a spinal needle just like the one that you used to do the injection, maybe you're going to burn a $4, $5, $6 spinal needle, but it's going to make that videotape deposition so much better for the jury when they are sitting there in court watching it. Number 3, sit still. Just stay still. Keep your body still. Don't move around. There are a lot of people who, when they're giving a deposition, they're very nervous. And maybe they're sitting in one of those office chairs or conference room chair that's on wheels where it can recline. You'll see them move back and forth, back and forth. Sometimes it's hard for the camera to stay focused on them and they come in and out of focus, in and out of focus. Or they'll move out of the view of the camera lens entirely and they'll be off screen, and if you're watching it, if you're a juror, you're watching this videotape deposition, you're just hearing them. You can't see them because they went off camera. Don't do that. Sit in one place and don't move. Number 4, look like a doctor. If you're a doctor giving a videotape deposition, maybe the lawyers are coming to your office after office hours. Maybe you're exhausted. Maybe you're going to do this quick deposition and then go work out at the gym, so you put on your workout clothes. Don't do that. Put on, if you're a man, put on a shirt and tie and put your lab coat on over it. Look like a doctor, because the jury is expecting to see a doctor testify. Number 5, break down the subject matter into easily digestible bites. When you're giving a videotape deposition in a personal injury case, you should understand that the people who you are talking to really have zero medical training. Maybe they didn't even take an anatomy class in high school. Maybe they have no idea what you're talking about. And so when you start using medical terms, you should pause and define them, even if the attorney doesn't ask you to. Because if the attorney is an experienced personal injury lawyer, that attorney is used to talking about fractures and, radiculopathy and herniated discs. They may not, in their own mind, realize they need to slow it down, break it down, and define these terms in the language that everyday people use. You need to do that. You should take control as the physician, take control and define what you're talking about. Number 6, understand the context. I've taken a lot of doctors' depositions, and sometimes they don't understand the context of the deposition. What's the case about? Are you being deposed in a case where maybe a lawsuit was filed against an auto accident insurance company that refused to pay somebody's medical bills, and really the issue is, were the medical bills reasonable and necessary as a result of the car accident? Are you being asked to give a deposition in a workers' compensation case where the real issue is whether the worker can return to work and should have their lost wages cut off? Are you giving a deposition in a negligence case where it's important for the plaintiff to be able to prove that all of the injuries and all of the treatment was caused by the accident? What is the context that you're giving a deposition in? What's the case about? These are questions that you should ask the attorney before the deposition. These are questions you should have answered for you before you even wrote a report, before you made the decision to get involved in the case. Number 7, understand the standards. There are different standards for testimony. In most cases, when we talk about causation, the causal link between an accident and injuries, In most cases, we're talking about a but-for standard. But for the car accident, the patient would not have sustained the whiplash condition. That's simple cause and effect. But in some cases, that's not the standard. For example, in certain workers' compensation cases where you have a cumulative injury that comes on over time, such as carpal tunnel, it may not be a but-for standard. It may be a substantial factor standard. In other words, was the work a substantial factor in bringing about the condition? You can find this out. Which standard is it? You can find this out from the attorney ahead of time. You can ask the attorney, what do you have to prove in this case? Do you have to prove that but for the accident, this would not have been the outcome? Do you have to prove that the work conditions were a substantial factor? What is it? Here's another standard. Do you understand that you have to give your testimony to a reasonable degree of medical probability? Or do you understand that you have to give your testimony to a reasonable degree of medical certainty? What does that mean? It doesn't mean that you have to be 100% sure of what you're opining on. You have to be more likely than not certain. You have to be, probable. You have to be relatively certain to say that this probably caused these injuries, to say that this treatment probably will be needed in the future. There's no certainty. It's not like a criminal case where you have to have proof beyond reasonable doubt. You just have to be satisfied, reasonably satisfied, that there is, a basis for your opinion statement. You should feel free to ask the attorney taking your deposition what the standard is for the admissibility of your testimony. If the attorney taking your deposition is going to tell you, doctor, I want you to testify to a reasonable degree of medical certainty, feel free to ask the attorney before the deposition starts, how do you define a reasonable degree of medical certainty? But understand the standards, understand what level of certainty you have to give your opinions. Number 8, understand the case, understand what's in the medical records, understand the past medical history, go over the physical exam notes. When you're giving a deposition, when I was a young attorney, I used to go to my father, who's my law partner, and I used to ask him all kinds of questions. And some of the time, he knew the answer to the question, but more often, he wouldn't know the answer. He wouldn't be able to give me the answer directly. What he would do is he'd get up and he'd walk across the room to a bookshelf and he'd pull a book, he'd flip to a page, and then he'd give me the answer. And I said to him one time, it's really interesting, you don't know the answer to every one of my questions. And he said, that's right, but I know where to find the answer. So this is my point to you. If you're a doctor going into a videotape deposition, you don't need to know everything. You need to know where to find things, which means you should go through all of the records ahead of time and map things out. Put tabs where you're going to need to go back to. And that way you can look at the record while you're testifying to refresh your recollection. There's nothing wrong with that. Number 9, let the lawyer lead. Don't fight with the lawyer, especially on cross-examination. Don't fight with the lawyer on cross-examination. Oftentimes it makes you look like you're trying to hide something. Just answer the questions directly. Slow the process down. Listen to the questions. Think them over and give a direct answer. Even if the direct answer harms the case, trust the lawyer who's taking your deposition to rehabilitate your testimony and ask appropriate follow-up questions. The more you let the lawyer lead and you're just there as the trusted advisor to the jury, the more compelling your testimony will be and the more believable your testimony will be. Number 10, sort of along the same lines, avoid giving evasive answers, or avoid giving accurate answers that come off somehow as being evasive. And here's what I mean by that. I have done depositions where the physician gives an answer to a question, but instead of giving a direct answer in a sentence, they give 5 or 6 sentences to explain where they're coming from, and then they give the answer. It would be much better if you just give the answer in a sentence, and then if the lawyer needs an explanation, let the lawyer ask for the explanation. The reason is because as the jury is watching you testify, the more information you have to give before you get to your answer, before you actually get to the answer to the question, the more evasive you come off as being, even if you're just trying to explain yourself. So your answer should lead with the direct answer and then explain, rather than give the explanation and then in the end come to the conclusion. Number 11, this is something I think is very, very important. Mandate prep time with counsel. Require that the lawyer who's taking your deposition come to your office 30 minutes or 45 minutes ahead of the start of the deposition and work with you to go over what's going to be asked, what they expect to be asked in cross-examination, what materials they're going to refer to. They're probably going to refer to other providers' notes and records and ask you about them, and you may never have seen them before. Don't let the time that you see them for the first time be in the middle of a deposition where you're being videotaped and you feel the pressure to review them quickly. I can't tell you how many cases I've had where I schedule the doctor's deposition and the doctor's office says, well, if you want to meet with the doctor ahead of the deposition, there's going to be an extra fee of however many $100, $500 more, $250 more for that half an hour prep time. And I think to myself, I don't need the prep time. I know the case, I know the records, and I know what the doctor should be expected to say. That prep time is not for my benefit, that prep time is for your benefit. So I don't think charging extra for prep time is wise. I think that discourages lawyers from wanting to prep you. And I think it's your prerogative to be prepared. It's your right to be prepared by the lawyer who is seeking your testimony. So I would say not only don't charge them, but make them come and prep you. Make them come and tell you what the issues are in the case. Make them come and bring the other providers' records that may come in at the deposition. Make them bring them to you ahead of time and review them with you ahead of time so that you're comfortable giving the deposition, so that you're properly prepared giving the deposition. Well, I'm Ben Schwartz. This has been another episode of 10 with Ben. I hope if you're a physician and you're watching this, I hope that you found it helpful. If you have questions, please send me an email. My email address is mail, M-A-I-L, @benschwartz.com. Thanks for watching.